Hello, this educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation is managing the HOA community, budgeting, setting assessments, and collections for past due assessments. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. The HOA budgeting process. A main function of the HOA's Board of Directors is to implement a budget for the community. The Board of Directors have the power to create and adopt a budget for the HOA granted by the Colorado Common Interest Ownership Act, also known as Kiowa. This is set forth in Section 38, 33.3, 302, and 303 of the Colorado Revised Statutes. The steps in the budget process include creating the budget. Either the board or their hired manager identifies the income, expenses, and goals of the association and creates an annual budget for the association. Next is to adopt the budget by the Board of Directors. Once completed, the Board of Directors reviews the prepared budget and, if acceptable, adopts it for the association and presentation to homeowners. Within 90 days of the Board of Directors approving the budget, a summary of the budget or the complete budget must be mailed or otherwise delivered to the homeowners. If mailing, use ordinary U.S. first-class mail. If otherwise delivered, then the association would also need to post the budget or its summary on the association's website. Within 90 days of the Board of Directors approving the budget, an owners' meeting date is set for the homeowners to consider the budget. The owners' meeting must occur within a reasonable time after the mailing or other delivery of the budget to the owners, or as allowed for in the bylaws. The notice of the owners' meeting must be mailed to all the homeowners as set forth with the requirements in the association's bylaws. The Kiowa law requires 10 to 50 days notice for all membership meetings. The next step in the budget process is to hold an owners' meeting to ratify the budget. For this meeting, normally a quorum is not required. If, however, the meeting to ratify the budget is taking place at the owners' annual meeting, then a quorum must be present in order to ratify the budget. Homeowner approval of the budget is not required unless the association's declaration requires affirmative approval of a certain percentage of homeowners in the association. The budget will be deemed approved unless there is a veto of the budget from a majority of all the homeowners in the association or a larger percentage that is set forth in the association's declaration. The next step in the budget process is the implementation of the budget. If the budget was ratified or approved as per the association's declaration requirements, the new budget takes effect for the association's new fiscal year. If the budget was vetoed or did not get approved as per the association's declaration requirements, then the last ratified or approved association budget continues to stay in effect until the new budget is adopted by the Board of Directors and then subsequently approved or ratified. The budget veto process applies to all pre- or post-July 1, 1992 HOAs. There is an exception to the budget process for the pre-Kiowa associations, where its declaration sets a maximum assessment amount or limits the increase in an annual budget to a specific amount, and the proposed budget by the board does not exceed that maximum or limit. The board is still required to send out notices and set a ratification meeting, however, even though no veto power will exist. Assessments for common expenses can be found in Section 38, 33.3, 315 of the Colorado Revised Statutes. Another duty of the Board of Directors of the association is to set and collect assessments. This involves both regular assessments and special assessments. Regular assessments, also known as dues, are the assessments which must be paid by the owner of each separate interest to the association every year, often on a monthly basis. The level of regular assessments is determined by the funds required to meet the association's annual operating expenses. Special assessments are needed when the HOA is short of funds, an unanticipated budget shortfall exists, or the Board of Directors has decided not to provide reserves or replacement funds for capital expenditures, deferred maintenance, or when the HOA experiences an unanticipated major expense. Examples might be a common boiler going out, or roof damage not covered by insurance. Assessments shall be made no less frequently than annually and shall be based on a budget adopted no less frequently than annually by the association. Common expenses shall be assessed against all the units in accordance with the allocations as set forth in the association's declaration. Any past due common expense assessment or installment thereof shall bear interest at the rate established by the association, not exceeding 21% per year. Common expense associated with the maintenance, repair, or replacement of a limited common element are assessed against the units to which that limited common element is assigned, equally, or in any other proportion the association's declaration provides. Any common expense or portion benefiting fewer than all the units shall be assessed exclusively against the units benefited. If any common expense is caused by the misconduct of any unit owner, the association may assess that expense against that owner's unit. Each unit owner is liable for assessments made against that owner's unit during the period of their ownership. Unless otherwise specifically provided in the declaration or bylaws, the association can enter into an escrow agreement with the holder of a unit owner's mortgage so that assessments can be combined with the unit owner's mortgage payments and paid at the same time and in the same manner. Assessment liens and collection are covered in the Kiowa law under Section 3833.3, 316, and 316.3 of the Colorado Revised Statutes. The association has the power to institute collection against a homeowner that does not pay their assessments. Lien for assessments. The association has a statutory lien on a unit for assessments levied against that unit or fines imposed against its unit owner after June 30, 1992. Unless the declaration provides otherwise, fees, charges, late charges, attorney's fees, fines, and interest can be charged. The amount of the lien includes all those items in the Kiowa law from the time such items become due. What about the lien priority for the association? An association lien under the Kiowa law is prior to all other liens and encumbrances on a unit, with some exceptions. These exceptions include liens and encumbrances recorded before the recordation of the declaration, a security interest on the unit which has priority over all other security interests on the unit and which was recorded before the date on which the assessment sought to be enforced became delinquent, and liens for real estate taxes and other governmental assessments or charges against the unit. An association, however, has priority over security interests to the extent of an amount equal to the common expense assessments based on a budget adopted by the association, which would have become due during the 6 months immediately preceding an action by that party holding a senior lien or performing a non-judicial foreclosure. A lien for unpaid assessments is extinguished unless proceedings to enforce that lien are instituted within 6 years after the full amount of assessments become due. Nothing prohibits actions or suits to recover sums that create a lien or prohibits an association from taking a deed in lieu of foreclosure, however. The association shall furnish to a unit owner, delivered personally or by certified mail, first-class postage prepaid, return receipt, a written statement setting forth the amount of unpaid assessments currently levied against the owner's unit. The statement shall be furnished within 14 calendar days after receipt of the request and is binding on the association. If no statement is furnished, the association may not have the right to assert a lien upon the unit for unpaid assessments. Costs and attorney's fees. The association shall be entitled to costs and reasonable attorney's fees incurred by the association in a judgment or decree in any action or suit brought by the association against an owner. What is a receivership? In any action by an association to collect assessments or to foreclose a lien for unpaid assessments, the court may appoint a receiver of the unit owner to collect all sums alleged to be due from the owner prior to or during the pendency of the action. The court may order the receiver to pay any sums held by the receiver to the association during the pendency of the action to the extent of the association's common expense assessments. An association's lien may be foreclosed by the following means. In a condominium or planned community, The lien may be foreclosed in a like manner as a mortgage on real estate, which is a judicial foreclosure. It may only foreclose on this lien if the balance of the assessments and charges secured by the lien equals or exceeds 6 months of common expense assessments, and the Board of Directors has formally resolved by a recorded vote to authorize the foreclosure. An assessment payment plan for unit owners is allowed in the Kiowa law under Section 3833.316.3. In collecting past due assessments and other delinquent payments, an association or holder or assignee of their debt shall make a good faith effort to coordinate with the unit owner to set up a payment plan that meets certain requirements. A payment plan negotiated between the association and the unit owner must permit that owner to pay off the deficiency in equal installments over a period of at least 6 months. The association, however, is not obligated to negotiate a payment plan with that owner who has previously entered into a payment plan under this Kiowa law section. This payment plan option, however, does not apply if the unit owner does not occupy the unit and has acquired the property as a result of a default of a security interest encumbering the unit or the foreclosure of the association's lien. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.